Your life. Good morning. It is April 30th. Senate Judiciary. We are taking up S-148. We have Wedge Counsel with us just to provide us a quick update with some information. And then I know we have Jill Martin Diaz who has to be out at 10. And so we'll make sure to get to you just to give you ample time for before 10. So Ben, the floor is yours.
Thank you, Senator. For the record, Ben Obergotsky from the Office of Legislative Counsel. So before the committee today is S-148, which we previously did a walkthrough of, but as a quick refresher, essentially this outlines the limits of law enforcement I guess collaboration with federal immigration authorities. It places restrictions on information sharing, use of resources, money, facility, property, equipment, personnel, and further spending civil, criminal, federal immigration investigation or proceeding, unless there is a judicially issued warrant or an independent investigation unrelated to immigration enforcement. There's also a special nod, if you will, to ensuring that these requirements to law enforcement officers and other persons acting on behalf of an agency in a situation regarding legally protected healthcare activity or reporting a drug dose and providing immunity there. So it's really just kind of a belt and suspenders approach to ensuring that law enforcement that are involved in those situations are explicitly held to the restrictions contained in S-148.
I'm wondering if it's in a different place in law, but I know last biennium we added drug checking to so the drug checking sites were given immunity, like Good Sam, and I thought there was some immunity for reporting human trafficking as well. That sort of falls under.
There is. I have to double check to get like the specifics, but I think the way that the immunity plays in the human trafficking context is if a victim is essentially commits a crime as a result of being trafficked.
Yes.
There's immunity there.
When I want to bring, and I ask because I want to bring in those aspects as well and make sure that there's that additional. So when I sort of think of Good Samaritan laws, it sounds like they exist in multiple places in statute, but I want to make sure that we're sort of belt and suspenders protecting those areas.
So when you say sort of expanding immunity in the human trial, like so what as applied how?
So I want to make sure that if someone is a victim of trafficking, they're probably the most likely to potentially have questionable immigration status. I want to make sure that they're definitely protected by this.
Okay. Yeah.
So I think it's just looping in a couple other areas of law.
Yeah.
I figured it might be able to be.
So if any questions about the bill as it currently exists or potential additions, just before I think we get into additional, I guess, potential issues to consider.
Yeah, I want to talk about the potential issues. I know last time when we got to walk through the general assessment that this would be a sort of constitutional gray area. And I wanted to take a deeper dive into that and figure out what areas can make more black and white instead of gray.
Right. Well, on the one hand, some of this, while this is relatively broad, these restrictions, there is a way, and other states have kind of built it out, so to speak, so it's more explicit about what it means for not to expend or use time, money, facilities. For instance, Illinois has a statute that does that. It does other things as well, but it breaks down sort of the specific scenarios that are prohibited. So, for instance, not extending um, uh, a Terry stop, for lack of a better term, to make sure that immigration authorities can arrive to do their investigation. To not abide by immigration detainer requests, and things of that nature. The controversy, or I guess constitutional gray area, that from my perspective is most gray, is information sharing. So there are two federal statutes that require information sharing in the immigration context. 8 USC 1644 and 13, I believe 73. Those essentially require information to flow from state authorities to the federal immigration authorities as part of their plenary powers to enforce the immigration laws. This issue has really not been decided by the Supreme Court. And when I say the issue of what can the federal government require of the states, implicating the 10th Amendment, which the states are their own sovereign, and powers that are not explicitly provided to Congress are reserved for the states. But that conflicts with the supremacy clause, which is federal law is supreme. What the Supreme Court has done is really they have not weighed in on the constitutionality of these statutes, but various circuit courts have. The Second Circuit has, the Seventh Circuit has, and they are split. But they have not ruled on the specific information sharing issue itself. They've sort of ruled on what I would categorize adjacent issues. So like grant funding. Though there are two cases, City of Chicago v. Barr, that's a Seventh Circuit case. It's a 2020 case. And then there's State versus the Department of Justice. That's a Second Circuit case. So the Second Circuit has held that the statute on its face, or rather as applied, is valid, meaning you have to do it.
Which statutes?
With this one was 1372, I believe, or three. But they kind of ruled on different grounds for it. But to kind of pierce through all of the legalese within these concepts of states' rights versus the supremacy clause, there is sort of this interplay where the government can encourage the states to follow federal policy and law, but that encouragement can't venture into coercion. So a good example of this that has been litigated is federal highway funding and increasing the drinking age to 21. That was a national initiative to get the states to adopt that rule. So they kind of tied highway funding to states that would increase their drinking age. So that's an example of it.
Senator Bosley.
In the Second Circuit case where they ruled that states have to share, is that they have to share if they're asked for the information, or they just have to have?
Well, so they're not really, they didn't get to that specific issue. So what they talked about in relation to these statutes is the ability to issue grants to get states to comply with that statute, or that requirement rather. So again, it's sort of that adjacent issue of, can we use grants to kind of encourage them? And the Second Circuit said in this instance, and it was very fact specific in my view, they could do that because the grants that were tied to the funding, so it was these law enforcement assistant grants, right? So there's sort of a nexus contextually between sort of immigration enforcement, enforcing laws, and law enforcement funding. In the Second Circuit case, they said the amount of funding that the jurisdictions would lose was not enough to essentially be coercive. I believe it was only like it was either 1 or 5% of their total budget. And they said essentially that's not enough to be coercive. That's just an amount that can be encouraging. And there's a lot of other factors that went in, like, they had to certify compliance and whether those certification documents were coercive as well. So there are a lot of various factors, but in my view, the real key issue that they decided in the Second Circuit was that amount, and threatening to withhold that amount if they didn't certify compliance with the statutes wasn't enough to be a coercive factor, and therefore the statute is valid. Seventh Circuit decided differently, but kind of on different grounds. But we're a Second Circuit federal jurisdiction. So in my view, that is more informative than the Seventh Circuit. But the bottom line is that since there's a circuit split, Supreme Court probably weigh in at some point, especially given recent executive orders issued by the president, essentially threatening to withhold grant funding. So the information, like the actual flow of information and whether or not what the restriction is and that issue has not been decided. There has been a case that has sort of recognized tacitly in dicta that there's probably some confidential information that states can hold within themselves that they can't be compelled to share with the federal government, but it didn't discuss what that information would be. So these are really complicated concepts, but I just am trying to give a lay of the land of these issues are really undecided by the Supreme Court. The Second Circuit, on sort of that adjacent grant funding language, has said that these statutes are valid as long as the amount of funding is not so significant as to be coercive. But there has been no true decision, in my view, on information sharing. So I don't know how the Supreme Court would decide on that one.
So that clears it up regarding grants, but could you touch on a bit more of the anti-commandeering doctrine? And let's say grants aren't involved, but we're just talking generally voluntary information sharing, or the use of facilities, the use of funds, state funds. I mean, can you talk a bit more about that?
Yeah, give me one moment to pick up some notes that I highlighted. So the 10th Amendment states that powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states or to the people. From the 10th Amendment text, the Supreme Court has derived the anti-commandeering principle, which prohibits the federal government from compelling states to enact or administer a federal regulatory program. This was sort of the preeminent case on that is Prince v. United States, which was a 1997 U.S. Supreme Court case. The court has in the past considered sort of facial challenges to the commandeering principle. So there's facial and then as applied challenges. Facial challenges are, does the text of the statute create a commandeering problem? As applied is, does the statute in practice create the situation? The Second Circuit case is State v. Department of Justice from 2020 decided that as applied, yes, the anti-commandeering statute or principle wasn't a factor and the statutes were valid. So in the past, they've also sort of talked about the facial challenge as applied to 1373, that statute. This was in City of New York, the United States, Second Circuit case from 1999. In that, the Second Circuit reasoned that 1373 does not compel state and local governments to enact or administer any federal regulatory program, nor does it affirmatively conscript states, localities, or their employees into the federal government service. Rather, the law prohibits state and local governments and officials, quote, only from directly restricting the voluntary exchange of immigration information with federal immigration authorities. So that reasoning said, facially, the statute's okay.
That was New York versus US.
Yeah, City of New York v. US.
2020.
That was the 1999 case. The site is 179 F. Dot 3rd 29. This was later acknowledged other in subsequent decisions. A notable one in a different context is the NCAA decision, Murphy v. NCAA. And that was where the Supreme Court had held that federal legislation prohibiting states from authorizing sports gambling violates the 10th Amendment's anti-commandeering statute. The reasoning that came out of that case was that it concluded in the Murphy case that the reasoning required it to hold 1373 facially violative of the 10th Amendment because the statute's prescription prevents states from adopting immigration policies contrary to these preferred by the federal court or extricating themselves from federal immigration officials. So that was a lower court decision that the Second Circuit then overturned in this state v. Department of Justice case. So this was sort of the conversation that was going on between the district courts and the appellate court. Is the district court felt that 1373 was violative. The appeals court said not so fast. So a commandeering challenge, though, to a federal statute depends on there being pertinent authority reserved to the states. That hasn't necessarily happened because that would mean that courts must carefully identify the powers reserved to the states in the immigration area in an area, though, that is otherwise extensive and complex federal legislation and the effect of the exercise on federal immigration laws and policy. So you would have to, the court would have to make the decision to say, okay, these are the specific areas that states have the power to regulate within this federal system of immigration. They have not broken it down yet. But they have cast doubt that it's doubtful that states have reserved power to adopt, and they reference the words of the district court, immigration policies that are, quote, contrary to those preferred by the federal government. So again, in dicta, they're indicating this is potentially problematic, but they're not going as far as saying what is problematic specifically. They reference McCulloch v. Maryland, which was one of the preeminent Supreme Court laws coming out of our founding by Justice Marshall. And he said that states have no power by taxation or otherwise to impede, burden, or in any manner control the operations of the constitutional laws enacted by Congress to carry into execution the powers vested in the general government. That's just another way of saying supremacy clause is supreme. But the states have some authority, but it can't burden or impede the policy of the federal government.
Senator Rogoski.
So this again brings me back to if there's a difference between sharing information you're not asked for just to share it and sharing information you're explicitly asked for.
Right. There is that difference. And so what states have started to do is essentially restrict that voluntary offering of information. However, when that information is required, they have allowed it. A lot of states will say, unless required by law. That's a common phrase that you'll see in a lot of these statutes. So, and the Supreme Court has recognized that there are some areas that the states might be able to regulate in the immigration field. But like I said, we just don't know specifically what. They actually did sort of, again, in dicta say that you could go the opposite way, requiring assistance to be provided. But they didn't really delineate on the other side of the coin when assistance isn't provided. Any questions on, because these, and again, I'm trying to take it slow because these are really complicated legal concepts. And the immigration field is probably one of the most complex fields of law that exists. So I'm always going to be checking in. Any questions or concerns or thoughts?
Not that I'm seeing at the moment.
So this case went on to say specifically that Section 1373 raises no commandeering concerns as applied, and that kind of goes back to what I was saying before was sort of the extent of that grant and the amount and whether or not that was either encouraging or coercive. And they said that the amount was not coercive to amount to essentially commandeering the states to do what the federal government wishes them to do. And specifically, they said where Congress places conditions on the state's receipt of federal funds, whether directly or by delegation of clarifying authority in executive agency, because that was sort of at play here. There is no commandeering of reserved state power so long as the state has a legitimate choice whether to accept the federal conditions in exchange for federal funds. And then they go on to say that that legitimate choice is removed when those grant conditions pass the point into compulsion. And compulsion occurs when the amount of funding that a state would lose by not acceding to the federal conditions is so significant to the state's overall operations as to leave it with no real choice but to agree. And they decided that in various cases. One was the Sebelius case. After the implementation of the Affordable Care Act, the Supreme Court concluded that basically they were trying to get states to play ball with the Affordable Care Act based off of withholding Medicaid funding. And the Supreme Court concluded that the threatened loss of over 10% of the state's overall budget is economic dragooning. That leaves the states with no real option but to acquiesce in the Medicaid expansion. So that is an indication of sort of a dividing line of what becomes too much. So they said 10% of the overall budget, that's too far. There was another case out of South Dakota v. Dole, where the Supreme Court described a threatened loss of 5% of federal funding, which was less than 0.5% of South Dakota's budget. If the state did not raise the legal drinking age of 21 as only mild encouragement. So less than 0.5% withholding budget, that's okay. 10% of your total budget, that's not okay. So where that line is in between there, we don't exactly know. In this case, they said it was encouragement.
And none of these cases were deciding whether or not the state constitutionally could withhold information. They were deciding where the federal government could encourage her. So it's not actually deciding, none of them have decided what we're talking about.
Well,
they've just made decisions on how much money the feds can withhold.
Well, yes and no. I mean, so this was in the realm of that anti-commandeering principle, which is a part of the 10th Amendment, which is states' rights. And what they're saying is that interplay between states' rights and congressional authority or the supremacy of the federal government can be informed by the withholding of that money, those grants. So it's related to that interplay of states and federal government.
Yeah, no, I see how it's related. I'm clarifying that all of these decisions have been about how much encouragement the federal government can do, not about whether or not because the federal government is not saying you can't do that. They're saying, if you do that, we're not going to give you this grant funding.
Right.
Yeah.
Yeah. But yeah, so I mean, I guess I think what you're saying is what I was saying before, is that they haven't really gotten to that part of the issue about really the dividing line of what information can be held or not.
Right. Yes, that is what I'm saying.
Okay. I'm with you. Any other questions?
Can you just go back to Murphy?
That just really stands for that anti-commandeering. Yeah, just framing the issue, if you will. But factually, it's completely different from from what we're talking about here.
Well, I'm trying to get more to what was described in that case and in the appeal, what was described as the pillars of the anti-commandeering doctrine. And that's what I'm trying to get a bit more.
Right, and I think the Prince case is really sort of the seminal case that really delineated this. City of New York, that 1999 case is another one that talked about it from a facial challenge to 1373 specifically. And then there's the Murphy case, which again is about sports gambling. And they said in that case, the sports gambling prohibition on the states by the federal government did violate the anti-commandeering statute because it dictated what legislatures may or may not do. It wasn't really tied to grant funding or anything like that. It just said you can't have sports gambling. So that was clear prohibition on the states. And they said that violated the 10th Amendment's anti-commandeering principle.
Yeah, there was one component of that they highlighted just as the foundation of the anti-commandeering doctrine, one of which was to prevent Congress from shifting the costs of regulation to the states. And that is what I'm thinking about in regards to this bill. In the event that, well, I mean, it's already happening, but as more immigration action happens and there is a increasing request from the federal government for state authorities to help them and state facilities to be used, I'm wondering, at what point does it cross the line of shifting the cost of regulation or what is a federal responsibility, immigration, when it crosses that line into shifting that burden onto the states? That's what I'm trying to get at.
Yeah, and that's something that I have to do a little bit deeper of a dive in to speak intelligently on. But another factor that I think is a distinction between the Murphy case and the immigration field is, the in the State v. Department of Justice case, the 2020 Second Circuit case, when they were discussing Murphy, they were discussing the fact that, it was unquestionable that the states had the police power to regulate sports gambling. It's different in the immigration context because the federal government holds broad, sort of extensive and complex plenary authority in the immigration field. So that's a little bit of a difference between the two, is that the authority that the states had in the Murphy case was clear. It's not so clear in the context that we're talking about in immigration. So going to your point about, cost shifting, I'd have to look into it more about how that distinction factors into the cost shifting analysis as well. Okay.
Yeah. Any other questions? Okay. And unless you have anything else, I'm gonna shift over to Jill. Thank you.
Be in my seat.
Good morning, Senator and the committee. Can folks hear me okay?
Yes.
Wonderful. May I proceed? Just for the sake of time, I want to make sure we can speak
Yes, floor is
as
yours.
much as possible. Fabulous. Thank you. For the record, I am Jill Martin Diaz. My pronouns are they, them. I am a seasoned immigration attorney and educator, and I'm the executive director of Vermont Asylum Assistance Project. Vermont Asylum Assistance Project is a leading coordinating body of removal defense legal services in our state. We're working to provide direct legal assistance through our own staff, as well as private pro bono counsel from the Vermont Bar Association. And we're doing system-wide capacity building and technical assistance, including for all branches of government. I just want to name that while I am testifying before this committee today, there are a few things that VAP staff and volunteers are doing that I want to lift up into this room. One, we currently today have staff litigating bond motions requesting Vermonters' release from immigration detention in Texas immigration courts, because that is where Vermonters are being relocated now as the Northeast beds fill up. We also have VAP staff who are preparing unaccompanied minors for their asylum interviews, children who are single digits in age, whose funding was cut. The legal aid funding for unaccompanied children was cut in March, which saw our organization lose 6 figures of funding. And their asylum interviews are continuing anyway. And so our staff is currently working busily with those people to prepare them to give them a fair shot at prevailing in their meritorious asylum claims. We're also running a legal clinic with VAP volunteers that we've mentored through the Vermont Bar Association this evening to support 3 farm workers in removal proceedings to file their initial applications for asylum with meritorious claims. And we're closely following the hearing this morning of Mosen Madawi in the District of Vermont, in close partnership with ACLU Vermont, providing them with expert testimony on common issues of immigration law and practice here in Vermont, and trying to inform ourselves as we file lawsuits in other district courts around the country as an organizational plaintiff to try and shore up other areas of due process, privacy from unfair government overreach, and free speech that are under attack by the administration, not just for immigrants, but for everyone. What we're seeing in the community, in the community level of immigration practice, is that immigration enforcement is increasingly relying on data sharing, not just between law enforcement, criminal law enforcement, and immigration and customs enforcement, or the Department of Homeland Security, but through ancillary agencies that the federal government is co-opting for the purposes of immigration enforcement beyond their own authority as delegated by Congress when they created those other bodies and charge them with buckets of responsibility, but also now at risk of commandeering resources from the states. We're seeing that the federal government is commanding the Internal Revenue Service, Health and Human Services Department, the Social Security Department, even the United States Postal Service, which was reported yesterday, using information and resources gathered by those agencies to effectuate an anti-immigrant mass deportation effort. And when I say an anti-immigrant mass deportation effort, I mean that there are very clearly enumerated rights and responsibilities and due process protections in the Constitution and in statute that we see the government routinely violating in the course of its administration of immigration proceedings pertaining to Vermonters. People are not getting their access to counsel and access to a full and fair hearing. They are not getting access to due process. And what we're concerned about is that this system that we're seeing unfold before us is not just an impact on immigrant Vermonters, which it is most immediately, but that long term, we are seeing the very core tenets of our constitutional democracy erode before our very eyes. The number one way that a Vermonter is currently becoming entangled in the detention and enforcement system is driving. Traffic stops are the number one pipeline. Anytime a Vermonter leaves their house, they are at risk of coming into contact with a law enforcement agent who then will take their fingerprints if they are being charged with some kind of offense, even a de minimis road offense. Immigration and Customs Enforcement has the ability to affirmatively search pursuant to 1373 has been shared, to search the databases of who Vermont is arresting. And then the Department of Homeland Security can choose to prioritize its resources for going to that person's address, waiting for them outside so that they're intercepting them in public, therefore subterfuging the need for a judicial warrant and taking them into ICE custody. Because this is happening, and this is happening at an alarming rate, not compared with historically what's been experienced in the United States, but alarming for Vermont, we are seeing a mass chilling across our communities. Every week, VAP hosts a community case rounds for 2 hours where we invite legal and lay advocates to bring anonymized versions of common fact patterns, questions, FAQs to talk about as a group, to make sure that everyone is informed about the difference between what the law says and what normatively is actually happening. And what we are hearing is an ever increasing rate of people who are not afraid to drive their kids to the school bus stop, afraid to take their kids to health clinics and youth groups, people who are missing their health appointments. I even heard one story of a Vermonter who has an advanced form of cancer, who no-showed their oncology appointment at UVM. And when asked why they did this, they said, I can't risk being on the road, even if you have a driver privilege card, because the risk of a busted taillight is too great. And for some immigrants, that's what's at stake right now, right? This fear of this zero-sum thinking between, can I drive to my life-saving oncology appointment? Or is it better to shelter in place like we did in the early months of COVID? So even when, and Vermont has a lot of really amazing diversion programs and treatment courts and a nationally progressive prosecution bar. And yet, even when Vermont has settled its score, the people of Vermont have settled its score with defendants in criminal matters, the immigration system doesn't care. All they need to know is that someone who they could charge with removability has had contact with Vermont State Police. That celebrates the proposals of this bill and strongly encourages support from the Senate, because it will not only protect people's public health and public safety information, quite literally, right? It will shore up what we've created here in the fair and impartial policing policy to help Vermonters understand that public health and public safety emergency response that has been delegated to the states to take care of, that it is safe to access the help, the life-saving help that you need when you need it, regardless of your immigration status. I think that it also will show some much needed leadership for our state at this time. Right now, the state is.
Jill, we just have one question from Senator Norris.
Yeah, hi. Good morning, Jill.
Good morning.
You had made reference to the fair and impartial policing policy here in the state of Vermont, and that this would shore up. What would shore this up that's not already in the fair and impartial policing policy in your mind?
Well, for me, policy is policy and statute is statute. I think that I think it was an amazing first step to encourage cooperation at the local law enforcement level to come into compliance at a minimum with the floors set by the statewide model policy, and to do that by statute. But what we're seeing right now is not individual locality challenges. We're seeing a systems-wide challenge that really calls for systems-wide solutions. And relying on individual localized law enforcement agencies to be responding ad hoc and piecemeal to collectively raise up the protections that Vermonters have to access public safety and public health systems is not going to be as effective or resourceful, like economical for us as a state, as a top-down systems-wide approach. So for example, I know I've spoken with you all about the lack of coordination and the ways that thwarts our efficacy as legal service providers. So in the last few weeks, the many high-profile arrests and ICE detentions that have transpired in our state, the lack of coordination has just been so palpable. Besides the ample legal work that my organization already had planned for people who need our help getting out of detention, who have claims to do so and would prevail with focused legal attention. We instead were fielding mass called outcries from community members, from leaders, from lawmakers, because no one is clear on who's doing what, who to call for help, who has what expertise. And to me, that's an example of a system level problem, this mass deportation threat that doesn't yet have a system-wide solution, which is this group thankfully has supported. The Senate voted S56 to advance to the House to create immigration coordination at the state level in the Office of New Americans. But I think similarly, what we're seeing right now about Immigration and Customs Enforcement co-opting not just other federal agencies, but seeking to co-opt state resources to effectuate its purpose, is that we really need a top-down approach, even just a communication, like the way that this would communicate to the public that it is in fact safe to go to the hospital, to go to the police station and call for help, to seek protection for someone who's experiencing an overdose or some kind of form of sex or labor trafficking. That's the message that I share in the numerous Know Your Rights sessions that I'm requested to provide to stakeholder groups every week. But that's not, legal, it's normative. What we are hoping for is a source of authority to communicate sector-wide to all different kinds of emergency responders, not just Vermont State Police who are patrolling the highways. Like a person needs to be able to seek protection when they need it. And I agree with Ben's understanding that the bill, and as Senator Vahovsky has pointed out, this bill, my reading of it, does not prohibit a response to lawful requests for information initiated by the federal government. Instead, it doubles down on the purpose of the fair and impartial policing policy and sends a message to state employees and their delegates that this is not information to be unnecessarily collected, let alone unnecessarily shared. Because when we do that, people don't call for help and they get hurt. Thank you,
Jill,
Senator.
one question I had. You had mentioned something earlier that made me think of it. I know we've got the fair and impartial policing policy, and I know that in this topic of conversation, I feel like the first thing, myself included, that people jump to is what's law enforcement doing. But I think your point about other agencies, I think you had mentioned the DMV, maybe. But I mean, do you think that it's more or less useful to include other agencies such as DCF or the DMV in this information sharing system that would be, or lack of a system that would be established in this bill for the pro business? That makes sense.
Thank you, Senator, for the question, because that was something I noted in looking at the provision at 2372 subsection A. So I'm on page 2 of the bill as introduced at line 1. I noticed that the bill as introduced enumerates examples of federal agencies, but including but doesn't limit a list of federal immigration authorities that the bill might pertain to, but doesn't similarly enumerate state agencies that would be subject to the bill. And I was curious about, whether the relative merits of enumerating examples and being inclusive at the risk of losing, at the risk of continued advancement by the federal agencies to co-opt more and more and more adjacent systems, non-immigration systems. So like this announcement yesterday of this story of a USPS person sharing information with ICE so that ICE could effectuate a removal is obviously very chilling. And that's something I wouldn't have guessed. I think about Health and Human Services and the DMV. Like there are some other agencies that come to mind first of a place where the feds might go looking for immigrants personally identifying information. USPS wasn't one of them, but I'm naive. What do I know? I think that enumerating without some room for growth risks limiting the efficacy of the bill as the government continues to look more and more aggressively toward other agencies whose resources it can co-opt to effectuate its immigration purpose.
Sarah,
I wonder, and this might actually be a question for Ben, if a mechanism by which we can sort of cast a wider net would be to name instead state resources rather than so narrowly on law enforcement resources.
Yeah, well, just to provide context on the bill, so this law is being added to Title 20, which is the public safety title, specifically within Chapter 151, which is the Vermont Criminal Justice Council. in that chapter, law enforcement agency is defined. So that's, and initially that was the, I guess, the angle for this bill was as applied to law enforcement agencies, officers, and those acting on their behalf. So, it's a policy decision to expand it to other state agencies or employees. But just to give kind of context about why the bill is currently framed this way. But if the committee wishes it to be broader, that can be done.
A quick follow on that thing, just for clarification purposes, does the DMV already consider law enforcement agencies?
There are law enforcement agents within the department. Though I don't think DMV itself is considered a law enforcement agency. I would have to double check the definition of the agency within Title 20 because it does enumerate certain ones. But there's sort of a catch-all, if I recall, that anyone that's certified as a law enforcement officer, which there are DMV employees that are.
When I think, even if the DMV is, what Jill brings up to me that gives me concern is DCF and actually the agency, AHS. Is those organizations that might have that sensitive information, that I know, and I know DCF also has some sworn law enforcement investigators, but I am fairly certain the entire agency is not a law enforcement agency. But I think about not just child protection, but economic services, fuel assistance. I think of those are some other organizations, which is why I sort of think the broader sort of catch-all of state agencies or state resources may create that net without enumerating a list. I hate lists actually, because you inevitably leave stuff off the list.
On that point, so all of AHS though is considered, I forget the specific term, but essentially I think a healthcare provider, for lack of a better term, under HIPAA. And so when we're talking about confidential health information, that is a factor that could be considered within this broader context.
Yes, thank you. I might add on that subject, I think, focusing on the enumerated agencies at subsection A, to the extent that this committee would be willing, I would also consider a similarly expansive view of what federal immigration authorities are. For example, we've already seen ICE or, immigration arrests effectuated by the Bureau of Alcohol, Tobacco, Firearms, and Explosives here in Vermont. And we see other agencies, the U.S. Marshals Service, the Department of Justice, FBI being mobilized to use their resources for civil immigration detention enforcement as well as criminal immigration enforcement, which is a very limited part of the statute. But it's not just Department of Homeland Security law enforcement agents that are causing this chilling effect at the risk of public health and public safety in Vermont. The committee does not have any final questions for me at the moment. What I would just share, zooming out, as I think about what we're seeing on the ground and the problem that this bill is trying to help solve. I agree with Ben's characterization of the plenary power doctrine and also the Chevron doctrine in federal court system that have conspired over the generations to put immigration enforcement in this like virtually unchecked and very risky place. It's an area where an authoritarian government has a lot of previously never before reviewed discretion to try to experiment with expanding power. And immigration law was written in an explicitly racist way until 1962. There were on the books literally, racial quotas in caps describing who has the right to have rights and who doesn't. And I'm concerned as a lawyer generally, not just as an immigration advocate, about the eroding rule of law. That immigration is fertile breeding ground for experimentation with expanded executive authority. And I agree that there are areas that the court has not taken up in immigration matters by design. And I encourage Vermont to continue to lead courageously among the 50 states in advancing constitutional and civil rights for all, in ensuring a government of checks and balances. Vermont is unfortunately unique among the states in still preserving its common benefits clause in our state constitution. And I appreciate that I'm practicing law in a state that has been, in charge of many firsts in terms of constitutional and due process and democratic advancements. And I see this bill as making progress toward that same tradition. So I thank you for your consideration. And if I can provide further case examples or other perspectives, I gladly return.
Thank you. Appreciate your testimony. So next up, we have Jim.
Thank you very much to the committee. Have a good day.
You as well.
Morning.
Morning.
My name is Drew McManus, I'm the State Department of State's Attorneys and Sheriffs. We appreciate being invited in to comment on S-148. I know tomorrow you all have a joint session for reviewing fair and impartial policing. I believe it'll probably be a very deep dive into the fair and impartial policing policy. I will highlight a few of those pieces today as I think they're important to note in context of some of the issues we see in this bill. And I would just note that while I'm not here on behalf of the Criminal Justice Council, I was previously the Associate General Counsel for the Council and advised the Council on the FIT policy when it was updated in 2024. And the Council wrestled with a lot of the legal issues that are being questioned here today. So I'm happy to supply any information that I can from that context as well. But again, I know you have a lot of scheduled tomorrow, and that the Council will be speaking directly to you on this. So the primary issue from the State's Attorneys and Sheriff's Department, and in this context, I'm speaking from the side of our house of our sheriffs and their departments, is the issue on line 8, highlighted by Ledge Council. Do you provide any information? I respectfully would push back a little bit on Legislative Council's analysis of the federal law. And only in the, well, we all have opinions, but here's our opinion from our department. The issues raised on the federal level regarding USC 1373 and 1644 have been brought up into the courts based on regulatory issues. The issue when argued was whether or not the statutes were lawful under the 10th Amendment. And the Second Circuit in State v. Department of Justice affirmatively stated that the federal statutes are lawful, 1373 specifically, and 1644 in very similar language. So we often kind of lump those two together. If this bill passed as written, stated that no law enforcement agency or officer or other persons acting on behalf knowingly provide any information regarding civil or criminal federal immigration investigations or proceeding, that would put law enforcement agencies in direct violation with federal law. It would also require the Criminal Justice Council and all law enforcement agencies in the state to revise their fair and impartial policing policy. And that revision, if it followed this bill, would violate federal law and it would violate state law. 20 VSC 2366. In 23 VSA 2366, which is our law mandating that we have a fair and impartial policing policy, and the agencies must adopt it and review it every 2 years. It states in section F, nothing in the section is intended to prohibit or impede any public agency from complying with the lawful requirements of 8 USC 1373 and 1644. To the extent any state or local law enforcement policy or practice conflicts with the lawful requirements of 8 USC 1373 and 1644, that policy or practice is, to the extent of the conflict, abolished. So, in effect, if there's a statutory mandate that all information was restricted, if an officer, the impact, one, it puts all agencies in a potential position to have the federal government looking specifically at them, not the state of Vermont, but the law enforcement agency, who has now adopted a policy that is in direct conflict with federal law. And then also, if an officer is in violation of that policy, per state statute, that section of the policy is abolished. And you would not, if that officer contested that misconduct complaint, the Criminal Justice Council is not going to be able to use that section of the policy per 20 VSA 2366. What's really important to understand about the federal statute is the way it's worded. So many papers here, because it's so complicated. You need a field of information. The federal statute doesn't require communication. What it says is that, and I'll just read it out loud for everyone, notwithstanding any other provision of federal, state, or local law, a federal, state, or local government entity or official may not prohibit or in any way restrict any government entity or official from sending to or receiving from the Immigration and Naturalization Service information regarding the citizenship or immigration status, lawful or unlawful. So it doesn't, it's that an agency cannot prohibit its employees from voluntarily communicating information regarding the citizenship and immigration status. And that prohibition is what, when you go into the federal case law, Murphy, the issue, one of the issues of many was, are you making a state do something or are you preventing them from doing something? And Murphy said, it doesn't matter which way. If you jump into what state powers are, it doesn't matter how you word it. That's what Murphy decided. And then a number of districts took that. And then that was around sports gambling. They took that, doesn't matter if you prohibit or require, and then applied it in immigration type cases. And the Second Circuit, after Murphy and noting Murphy's ruling, said, yeah, we understand that it doesn't matter whether it's a prohibition or a requirement. Okay, we agree with that. But the issue is, whose power is this? And the Second Circuit and State v. Department of Justice stated clearly, immigration is a federal power. It is not a state power. And just to read directly from that case, nor can we agree with the district court, so they're disagreeing with the district court ruling below, that the challenged conditions impermissibly intrude on the powers reserved to the states. As the Supreme Court has repeatedly observed in the realm of immigration policy, it is the federal government that maintains, quote, broad and, quote, preeminent powers, which is codified in an extensive and complex statutory scheme. Thus, at the same time that the Supreme Court has acknowledged states, quote, understandable frustrations with the problems caused by illegal immigration, end quote. It is made clear that a state may not pursue policies that undermine federal law. So, a reminder to this body, when there were concerns about federal overreach in the I shouldn't say overreach, because again, immigration is exclusively a federal power and is not one shared with the states. But a few years ago, when there were concerns around this issue, this body amended 20 VSA 2366. And they specifically, meaning you all, specifically added the language at the end of what I just read earlier, that you put in the language lawful requirements of a USC 1373-64. And my understanding, what I had been told with those who were involved closely with that, is that language is very specifically added because even then there was this conflict of federal cases. And essentially, as this reads, if the Supreme Court ruled on this issue and said, you know what, these are unconstitutional, they would be unlawful, and then this provision would no longer apply in the law as far as abolishing that kind of policy. So I'm just, again, I know you are going to be very deep in this tomorrow, but that is the key issue from law enforcement's perspective. That if you put in the language, any information, that puts us, law enforcement, in direct conflict with federal law that is currently lawful under the Second Circuit. The FIT policy will be very important when you all sit through tomorrow's hearing. You will see how the council navigated this territory. And what it did was it took the federal statute and it read it as narrowly as possible. And so when you go into the FIT policy, when you go into the FIT policy and you go specifically to communications, which is in section 6D7, these are prohibitions on communicating with federal agents. It says they cannot share any information, and then in parentheticals, other than information regarding citizenship or immigration status, and parenthetical about any individual federal immigration authority. And then there are some exceptions for public safety. And also law enforcement needs that have no relation with federal civil or criminal investigations. The policy then further lists what are things other than immigration status. It's very, very small. It's one tiny piece. Things that we would be concerned about sharing and that the policy already limits are things like physical appearance, current whereabouts, places of residence, telephone number, social security number, vehicle license plate number, family relationships. That is already strictly curtailed in the FIT policy. And that was done with an awareness that having local law enforcement be seen in any way to be participating in immigration efforts is incredibly corrosive to their communities. This is not an interest of local law enforcement. They cannot be involved in federal civil immigration investigation. They have no purview there. They can be involved in federal criminal, but again, the policy strictly delegates when and how. I would also, one other piece to note tomorrow and to listen to is the restriction on access to facilities. and the restricted access to individuals. This was all very carefully and in a nuanced manner laid out in this, I think it's 14-page policy. 12-page policy. This bill, again, would require revising this policy and most importantly, putting it in jeopardy of actually being enforced, the actual areas that I was concerned about. Currently, this policy restricts our local law enforcement in how and when they can communicate with federal agencies, but it allows us to not be in violation of federal law and is defensible if challenged by federal government. So there. So
I guess my first question, if hypothetically we took the phrase any information out of line 8, what would your position be on that?
I'm sorry, did you say line any information?
Just the words any information, but kept in expending or using time, money, facilities, etc.
We would want again, this is no. It's a complete exception to law enforcement. So what I would say is I would want to check in with law enforcement to see if there was any reason. Again, the policy strictly prohibits use of facilities. I don't know as far as what property, equipment, or personnel would be covered by this policy. I would want to look into that closer to see if law enforcement had any reason to have that connection. And I do believe you're going to hear from we're more concerned about the information sharing because that again puts us in direct conflict.
And just to make sure I understand from earlier, your testimony was that the fair and impartial policing policy as it's written now is more specific as to what information can or can't be shared. You went through some demographic information, and that policy is more specific about the information, but your concern is that the phrase on line 8 is too broad to a point that you believe it would be in conflict with federal law, right? So
correct. Yes, and again, when you get through tomorrow's session, I think you will hear that repeatedly. That and it's pulling out the words from the federal statute, information regarding the citizenship or immigration status. Federal statutes say that you cannot prohibit or restrict that information specifically about citizenship or immigration status from flowing from state or local to federal in either direction. And so, and again, the council has read that as strictly as possible. So the policy says can't share any of the other information. And then again, there's a few exceptions regarding investigations, public safety. But the policy does not restrict that citizenship and immigration status, and that's for lawful or unlawful. So it's not just unlawful citizenship. But that question, if the officer was questioned, their agency cannot restrict them from communicating that. Now, another important thing to note, in the policy, officers cannot ask about a person's citizenship or immigration status. So if they don't know that information, the answer is I don't know. So again, there's a very limited section when investigating crimes where citizenship is an element of the crime, like trafficking. But again, during the walkthrough tomorrow or overview, I think you're going to hear a number of safeguards that are already addressed.
just want to make sure want to summarize it one more time. Under the current policy, police officer can't ask about immigration status. They are required to share information about immigration status if asked by the federal government, but they're also prohibited from sharing other identifying information such as where the person is located, what they look like, anything and everything about the immigration status, which they're not allowed to ask about to begin with. And that is well, I'll just leave that there. Okay, so if actually, Senator Coles.
Under the current policy, if that's information that an officer has, are they allowed to volunteer that information if not asked for it?
So under the policy, again, it's that they cannot be restricted from sharing it. So yes, if somebody knew, if they knew your citizenship status, they could voluntarily share that citizenship and immigration status only and not be in violation of policy.
I think there's a pretty significant difference in giving information that one is asked for versus just volunteering information as one decides they want to.
Agreed. And again, to be in compliance with this federal statute, can't currently restrict that share, voluntary or involuntary, just the way the statute is worded. That is.
Yes. In fair and impartial policing policy, I believe it's my understanding that anyone who's committed a crime, the protection and immigration status is not covered, but it is covered for any victims and or witnesses of the crime as far as asking them or relaying that information. So that's a protected status, witnesses and or victims of a crime.
Yes, I'll read that section just to make sure, it's. So it states, in interacting with all people, including suspects, crime victims, and witnesses, agency members shall not ask about or investigate a person's citizenship or immigration status unless information regarding citizenship or immigration status is an essential element of the crime. So even a criminal suspect, it cannot be asked unless it's an element. And yes, but it does cover crime victims. There is an asterisk over the all people, again, to be in compliance with federal law. It says, as explained in section 6, federal immigration law permits a narrow category of voluntary communication with federal immigration authorities, i.e. those regarding citizenship and immigration status. You can't ask about it, but if you know it, then it can be shared.
So the policy, in your opinion, is very strict and yet protects officers here in the state of Vermont.
Protects officers, protects the agencies. It's as strict as council walk the line as narrowly as possible to not violate federal law, but to restrict law enforcement's interaction. And again, a very important thing to note, and you'll hear this tomorrow, the fair and impartial policing policy is not just about immigration. It is our anti-bias policy. There are section 5 and 6 are specifically about interactions with federal immigration authorities. So that'll be the pieces that you will hone in on and the definitions.
Yes. Okay.
So just for the record, my colleague in the Department of State's attorneys and sheriffs, I don't actually think we really disagree a whole lot. I totally agree on the assessment of that most recent Second Circuit case about how these statutes were upheld and that executive order and that was considered invalid. I think maybe where there's some disagreement is just specifically, so while there's the broad prohibition in this bill, there's also the exceptions for judicial warrant and an independent investigation. And I think my assessment comes from that where the gray area is, because of what those restrictions are, while on its face, I think to be interpreted one way or the other. I haven't come across a case that said specifically that that restriction or that type of restriction isn't valid, or what those restrictions could be. So I think that's where, just to clarify for the committee, that's when I say constitutional gray area, that's what I'm referring to. And so to not sugarcoat it, it could very well, that provision could very well be considered unconstitutional, but it also hasn't been decided specifically. I just wanted the committee to understand that. I guess defining lines like this.
Thank you. Thank you for your testimony. It's helpful. Actually, I'm sorry, committee, any last question? I forgot. I was just trying to stop it from here.
Oh, sorry. Fine. Thank you.
Jay, I'm not sure, do you have any time constraints? I know Officer Raymond's been here for a while.
Yeah.
Would you like to? Sure.
Morning. I'm Matt Raymond. I'm the commander of the Vermont Internet Crimes and Shore Task Force. Basically, we only investigate sexual exploitation of children. That's it. But we are partnered with Homeland Security investigations. We are task force officers designated with Customs Authority under Homeland Security. But I've been a task force officer with them for almost a decade, and we have never done any type of immigration enforcement. And in fact, our agreement with them specifically forbids any type of immigration. When the fair and impartial policing policy was being drafted, I'd actually reached out with concerns and on the 9th hour when I found out about them, about some of the facility restrictions that were being drafted, and built into that was the same kind of carve outs that are in the final sections of this bill, which are judicial criminal warrants and investigating basically another crime that has nothing to do with immigration. And so the way I would read this, and unless I'm reading it wrong, that carves out the information sharing between agencies. So basically, we're just investigating child sexual exploitation crimes, and since we have members of the task force that are federal officers, state officers, local officers, and sheriffs as part of our task force, then we can all share information about the crime of sexual exploitation of children with Homeland Security officers. But again, it would have nothing to do with immigration. And to follow up on that fair and impartial policing policy, that every law enforcement officer in the state has to follow, or their agency can't be part of the Criminal Justice Training Council, which includes certification. We are forbidden from asking about immigration status from suspects and victims and witnesses. So we wouldn't have any information to share because we don't know anybody's immigration status. So I think this is all already covered under the fair and impartial policing. And again, I would disagree with a former witness that said it's not a top-down driven policy. It is. The state mandates that every agency has to adopt the basic standards of the fair and impartial policing standard. So it already is top-down driven, and every agency has to follow it. And it's already precluded from being involved in any type of civil or criminal immigration enforcement.
Any questions? Comments?
I'm wondering, I appreciate that in the 10 years that this agreement, you've had this, agreement with Homeland Security and Immigration and Customs Service, you've never been asked to do any of that enforcement work. And I'm curious if you feel like at this point in time, things are pretty unprecedented and different than they have historically been in the immigration and customs arena.
Yeah, I would agree with that. However, built right into it is a preclusion from any type of, we are not designated any type of federal immigration powers, and is any type of immigration enforcement is precluded, is forbidden by the agreement. It's, and that's in the, that's a standard language in any of the customs enforcement. They give you customs powers, federal arrest powers. So basically, it's to be able to do federal search warrants, federal arrests, charge people federally with because child exploitation crimes, you know, exist both federally and state. And then cases will invariably go back and forth. We sometimes arrest somebody and then charge them federally, or they get arrested federally and charge them in state court, depending on what the best venue is to charge them in.
And that is precluded by the federal government?
By the agreement with the federal government, on their form, their standard forms. I know previously, this committee was looking at a bill regarding those agreements. And I'd seen testimony on it, and that was one thing no one had brought up, which I wanted brought up, is built right into those agreements, there's no immigration enforcement allowed. So it's you think of immigration as people and customs as things. So we're giving customs authority to regulate things. In this case, it's child sexual abuse material. That's the thing we're regulating. So, and you know, important to know is where our offices are actually located in the Homeland Security Investigation Building in South Burlington. Our whole infrastructure. We built 2 forensic labs up there for computers. We do no immigration with them. We do exclusively child sexual exploitation. But that's our offices. That's half of our personnel. We would be, you know, we weren't allowed to talk to them at all or use their facilities. Basically, the Internet Crimes Against Children Task Force would cease to exist in the state unless the legislature would, you know, come up with some serious funding and personnel fast.
Sure, maybe I've had this to stop that work, but there is nothing to stop the federal government from changing that preclusion and in fact having the agreement
Well,
and demand that you do.
We would have to have that agreement, but well, it would have to be signed by the governor and any changes to the agreement under the current law. So they can't just change that agreement without, you know, it's basically a contract, and each party would have to sign, so they can't just change a contract midstream. They would have to require us to re-sign in the current way that it's done. We signed this agreement before the first law was passed on that, and then there was just a revision this year. But any changes, modifications would require the governor's in consultation with the Attorney General's office. And we would never agree. Obviously, we would be in violation of the fair and impartial policing. We could all be decertified. Our agency wouldn't be able to use criminal justice training council services anymore, which would in fact decertify us all. So again, it's impossible, basically.
Thank you. Committee, any other questions? Thank you for your testimony.
Okay, thank you.
People like your advice? Sure.
Good morning, committee.
Morning.
Thank you again for having me. Jay Pershing Johnson, Governor's County Legal Counsel. So I'm very happy you're having the subject matter experts testify on impacts, because I think that that's probably, from my perspective, one of the most important things to understand. As you've heard, this bill would leapfrog state policy right over the carefully crafted fair and impartial policing policy and land us squarely non-compliant with existing state and federal law. With the clear intent to impede federal immigration law, this law would make Vermont a so-called sanctuary jurisdiction. I just want to be clear, right now, Vermont law and policy currently comply with federal immigration law. And as Kim mentioned, 20 VSA 2366 regarding fair and impartial policing is clear. To the extent any state or local law enforcement policy or practice conflicts with the lawful requirements of 8 USC 1373 and 1644, that policy or practice is, to the extent of conflict, abolished. So say the federal government were to challenge our fair and impartial policing policy and we were to lose that case, those portions of the fair and impartial policing policy would be void and unenforceable. And I think what's particularly problematic about this attempt is local law enforcement is not the problem. The state's fair and impartial policing policy is working. It was crafted carefully after years of legal analysis and stakeholder collaboration. Local agencies who fail to adopt or comply with the policy or take required training can be decertified by the Criminal Justice Council. As I said when I testified on S-44, I understand that this is a very difficult issue. People are afraid for their friends and families, for their livelihoods here in Vermont. And we addressed this same issue in a level-headed way in 2017. But some, I think, are so blinded by the emotion they are feeling about the administration in Washington, they have completely forgotten what would be best for Vermont, who is helped and who is hurt by this bill. A great concern is the fact that this bill will not protect anyone. It's a false promise of security. Moreover, it will have tremendous negative consequences, many of which we can identify and quantify, and many of which would be unintended. You will hear, and the Commissioner Morrison's testimony, I think, will be critical here. You will hear from Commissioner Morrison about potentially huge risks to our drug enforcement, emergency management, and other federal funding passing through public safety. The military department also receives funding for drug interdiction, and any gap in federal transportation funding going into spring-summer construction season will mean huge setbacks for our road and bridge project schedules. We will be unable to certify compliance with federal law. This is a standard grant requirement under any administration. You'll also hear about day-to-day operational impacts for criminal and first responder response in the state, particularly at our border communities. Regardless of the party in power, we need healthy relationships with our federal law enforcement partners at the border, as well as FBI, ATF, U.S. Attorney's Office, and others. Commissioner Morrison will also address consequences for victims of human trafficking, and you will hear about how a bill with language this broad can make our communities less safe. And you've heard from Officer Raymond about the AG's agreement with ICE, and he, right now, from what we understand, and their agreement would prohibit communications regarding immigration, but it is a customs enforcement agreement. It is actually subject to S-44 and the governor's approval, as he indicated. So while this bill, while well-intentioned, is focused on one problem, which it doesn't solve, and it jeopardizes the larger needs of our communities and our state operations. So that's my testimony on that piece. And like I said, Commissioner Morrison's testimony on impacts and critical. I was told that you wanted me to testify on the DOC MOU, but I don't believe there's language.
Yeah, well, before we go to that, just a few things. Since we're on the record, from where I'm sitting, my intent is not for the purpose of impeding federal law. Pretty sure that's a felony, but my perspective is the issue with the anti-commandeering doctrine, the shifting of cost burdens to the state, the blurring of responsibility for who is responsible for getting involved in immigration and investigations. That's my perspective on it. I do agree. The more I'm hearing about what law enforcement can and can't do, and the more I'm getting my memory refreshed about the FIP policy, I do agree that it's not just law enforcement that is. I don't think that local law enforcement is, quote, the issue here. I think that there should be a broader question as to, we alluded to this earlier, what is DCF's involvement, DOC's involvement, other agencies that don't quite have nearly the same guardrails in place that law enforcement already has right now. I think that we have a tendency to jump immediately to what law enforcement is doing rather than what other agencies may be doing. I do think that as the federal government is broadening its work in immigration enforcement and where they're getting information from, I think that does warrant the question of, rather than staying hyper focused on law enforcement, looking at how are other agencies potentially getting involved with this. I guess that's just a comment. One thing that's
Respectfully, I'm not sure how this actually approaches an anti-commandeering issue. I know with 287G agreements, we're talking about potentially, I mean, some of the language in the executive orders would suggest that the federal government can require a state to enter into 287G agreements or to otherwise enforce federal immigration law. But that in fact is not the case. 1357 specifically says that the federal government cannot require states to enter 287G agreements. And in this state, this is up to the governor. And if it was in the public interest of the state for public safety purposes, arguably the governor could enter into those agreements, and that would not be a commandeering issue. It's true, though, that constitutionally, the federal government cannot require state enforcement of federal immigration law, and that we are not doing that now. I am not understanding how this is an anti-commandeering issue. And I mean, the other thing would be that this bill is very specifically addressing law enforcement.
On the anti-commandeering issue.
you wanted to.
Yeah, I think from a legal perspective, they are connected in the sense that you've got to look at it holistically with the executive orders that have been issued, essentially threatening grant funding, and the fact that those grants were withheld under the first Trump administration. That's where a lot of this case law.
We did, I do respectfully, we actually did say at that time, 2017, our argument, rather than litigating at that time, our argument was we comply with federal law. And we actually succeeded in getting that grant funding before the states that litigated against the federal government, because we did comply with federal law.
So, but to continue on why the grant funding and therefore anti-commandeering issue exists is that is one of, I think it's safe to assume that it's one of the levers that might be used to get compliance. And if this law were to be litigated, that most likely would probably be an issue that's litigated within it. So it's not only just the facial challenge, it's also the as applied and what the facts and circumstances are when the case is litigated. And given the history of the cases so far, and that this is law enforcement, and law enforcement grants were one of the levers that were pulled in the previous administration. That's why the anti-commandeering, from my perspective as the legal counsel, comes into play. Is because it's something that's been threatened in the past in other jurisdictions and is currently being threatened now as a potential lever to pull to get compliance. And whether or not the level of assistance that's provided by the federal government to the state of Vermont, and the things that you discussed, the different funding, highway, all of that, how much those grants make up of the federal of the state budget, and whether or not compliance under this law is coerced through withdrawing that funding, and that implicates the anti-commandeering principle from my perspective. And so you have to take a deeper dive of going down that rabbit hole a little bit and seeing what's been done in history and trying to predict the future.
Well, I guess I don't understand that, just because what has been done in history is we comply with federal law. We are not, and this statute would violate federal law. I'm not sure understanding how you make a leap between the fact that we can currently comply with federal law without any kind of coercion. We did before 2017, we did in Trump 1, we did in Biden, and we are doing it in Trump 2. We comply with federal immigration law without any coercion, because it's in the, I mean, not because it's in the state's interest. We always have. I object to the idea that this is really just a matter of who's opposite board, right? Who is serving at the time. We complied under Biden, we comply under Trump without any coercion. And this bill would expressly violate federal law, putting us in a position where we can't certify compliance with federal law. I don't understand how that is a coercion issue.
Well, because the specific, in this, the exceptions to the prohibition, which I think are not being discussed. Judicial warrant and independent investigation, whether or not those exceptions are constitutional.
Why are we going into constitutionally gray areas when we don't need to? We have a fair and
Well,
impartial
the
policing
policy
policy.
decision, I think.
We have, it certainly is a legislative policy decision. I would agree with that. Governor is part of that process.
But my testimony was just to respond to you, Jay, on the anti-commandeering portion, so that to elucidate the fact that these issues haven't been litigated, it might be the anti-commandeering issue comes into play based off of the previous history and projected history. And so I'm happy to talk to you at another time to elucidate what I see as the anti-commandeering issue. But this is a policy position for the legislature to make. And what I'm highlighting for them are these potential issues as written, facially challenged, and then as applied. And the anti-commandeering issue, I think, would come into play as applied.
Senator, please.
I wanted to just, because I know you weren't in the room, we did discuss that this is narrowly focused to law enforcement and maybe should be and should actually be expanded up to a more, so I did want to point that out. And to answer the question of why the legislature might choose to weigh into constitutionally gray area, I think we have an administration that is wholesale disregarding the Constitution. And so it seems to me this might be a point in time where to protect Vermonters wading into constitutional gray area may make sense.
I simply don't see how it protects Vermonters. There's nothing you can do about federal immigration enforcement in Vermont. We are cracking down in this bill on local law enforcement, which is what people can get their arms around. But again, local law enforcement is not the issue here. We have a fair and impartial policing policy that works. You will see in DOC detention numbers, they go up, they go down, they go up, they go down, regardless of administration. So I guess I would say that you can't look at local law enforcement and say, you are the problem. We must tighten our grip on you. We must further reduce the tools that you have to combat crime in our communities.
So just to reiterate, what was just brought up a couple of times now, we're just having a conversation to see whether or not this path forward, or as it's been alluded to, whether or not this should not focus on law enforcement. A lot of focus does get put on law enforcement, but rather we should be looking at other agencies that don't end up under the microscope as much as police officers do. I think there is, where I'm sitting, a valid reason to step away from what we're putting, or what we're requiring from law enforcement at the moment, based on what we've heard about the PIT policy. But again, we'll look at other areas in which information sharing or state facility usage may be going to support federal regulations. That's the issue.
I mean, I guess I would just caution, as you seek to expand this policy, that any argument that the federal government can make that you would be harboring or impeding, impeding federal immigration enforcement or harboring undocumented migrants, you would be putting that DCF or other well-intentioned money at risk. While you are doing that here in the law enforcement context, you could certainly expand that risk to more agencies in the state.
It's not about clarifying. It's not the purpose of harboring, as you've described it.
I'm not describing it as harboring. I'm just saying if the federal government has a claim that we're impeding or harboring, we puts our federal money at risk.
So two things. When I hear witness testimony that individuals are skipping cancer treatment because they're afraid, I don't know that the fair and impartial policing policy is working, if that is what people are experiencing. That's not to say it's not a good policy, but I also think that statute is stronger than policy. And so I think there's this language, I think we've already decided in a couple of different points needs tweaking and changing to do what it's intended to do. But when I'm hearing testimony that people are skipping, not able to pick up their children because they're afraid, or skipping necessary medical care because they're afraid, it to me says that something needs to be done. So I think that when I think about, is it working? I don't know that it is, if that's what our Vermonters are experiencing.
I really understand your concerns. I just, again, would say that local law enforcement is not the problem.
I think that we have agreed that this shouldn't be solely focused on law enforcement.
Kind of veered off into a discussion, so midway in your testimony, so you have, more testimony you wanted to provide?
I just understood that you wanted me to testify on the VOCMOU. I don't believe there's any language, so I didn't know if you had specific questions for you.
There's no language that I have in front of me, maybe in my inbox, but,
Because it's a vibe too.
so I guess the conversation around the MOU, the way I have been contemplating this is that currently there can be seen that there are two categories essentially of detainees, in my opinion. There are folks who are arrested here in Vermont or having their hearings here in Vermont. And there's a second category of detainees who are arrested in other states, whether it's Boston or wherever else. And then they are promptly brought here away from their attorneys, their community, in whatever the original district is. And what I would like to explore is a policy change in which our state facilities are only used for immigration detainees who are either arrested in Vermont or are having their hearings here in Vermont, as opposed to being used for detainees who are brought here from elsewhere. I'm wondering if you have any thoughts or perspective on that.
Well, so I guess I don't understand. I guess there's two ways that I think about it. So if a person say we're currently in Louisiana, but we moved to Vermont, we would say, we're sorry, you can't hold her here. That would be one instance.
Why would they be moved to Vermont?
Isn't that right now happening? There's a motion. I mean, basically, there's the Vermont District Court has asked that the woman in Louisiana be moved to Vermont for detention.
Well, then,
But that's because her case is pending here.
right, and so she would be in the category.
So she would be moved in.
Yes, but to face
Her
court time.
hearings.
I see.
Yeah.
So her hearings are scheduled there. So, okay, so then my second question would be, this would be a contract negotiation, correct?
Mhm.
You give us the statutory limitations on our contract negotiating terms. What if, are these terms take it or leave it? So that if the federal government did not agree to our terms, which they don't have to, we say, okay, then sorry, we can't detain anybody here. Do you understand what I'm saying? Is
I
that
get what
we're
you're saying.
willing
The
to
federal
do?
government,
Are we willing to
could-
sacrifice the people we're trying to
I could
protect?
just finish real quick.
Mhm.
So I'm not trying to butt heads on this issue. I'm just trying to explore different possibilities of potential resolutions. And yes, that is a concern, and that's why we're trying to have a conversation about the potential pros and cons of creating facilities for who can be detained in state facilities pending immigration actions. So yes, that is one possibility, and that's why we're having the conversation. Senator Bruce.
If I might, so to the chair's point, I think what we're trying to do is respond to an evolving reality. I know the governor's office is trying to say. So in thinking about revised
MOU. So it runs out in August. It would need to be either re-upped or revised anyway.
Or terminated.
Or
correct? I
terminated.
mean, by either party.
Yeah, so I'm imagining that it's not, correct me if I'm wrong, that it's not the governor's intent to terminate the agreement, not have anything in its place. So I'm thinking it will either be continuing the same agreement or revising it. So what
You're assuming that those would be terms that the federal government would accept.
I'm just talking, I'm not getting.
I mean, you're asking me, I'm assuming you're asking me to do some testimony here. So my thought would be that this is a contract negotiation. Once you build in certain terms to a contract and say, Governor, you may not negotiate beyond these terms. The federal government says, no, thank you. It means we have no detention agreement.
We're not, you're leaving far ahead of where.
Oh, okay.
So what I'm saying is this will run out in August. So I don't think the government will terminate the agreement.
There's not a current.
Okay, so I'm imagining that it will either be continued as it is or revised. If it's continued as it is, then, that's one path. We're trying to explore how might it be revised with active participation with Fifth Floor, so that we could speak to some of the concerns that we have. What I think the chair was getting at with the two categories is there is a concern, I think it's a valid one, that this administration is building a network of detention facilities, some in our country, some outside of our country, some on the border, some not on the border. And there is great concern with Vermont becoming one of those facilities as a way station to move people ahead of judicial oversight. So one suggestion has been that we take care of our people, Vermont residents, people facing court here, people detained here, but that the MOU be revised to say if someone is a resident elsewhere, detained elsewhere, facing court time elsewhere, that we do not agree to host them or detain them in our facility, which seems as though it's within our rights in renegotiating. Now, of course, the federal government, as you say, might just flat out refuse to negotiate in any way, or they might propose more inclusive language in the new MOU that would require us to do more for them. But we're looking and hoping for cooperation as opposed to the governor's office saying nothing can be done. Anything that you do will be destructive in one way or another. And I'm hoping to hear from your testimony, is there any willingness to work on a revised MOU that might speak to the current situation more clearly?
Really, since I don't understand what you're saying, right? From my perspective, right? You're looking at a larger national issue, as you just described, a network of detention facilities, which PS we already have, which have been in place for many, many, many years, under all kinds of administrations. So being part of a national network of detention facilities is not the issue. You are worried about this leapfrogging in order to avoid any kind of court process.
Which we have seen.
Which institutionally the courts are addressing, right?
Okay.
So from my perspective, the issues are operational. Can the OC manage the kinds of requests that it's getting from us? Can it move people in and out at 3 o'clock in the morning? Can it keep people for up to there are, what we have seen, it's important to understand that these relationships survive administrations. Border security is a priority, or should be a priority. The Obama administration detained and deported record numbers of undocumented migrants. I don't believe there was any action out of this legislature at that time. In January and February of 2024, we saw huge spikes in detentions. I don't remember any action last year on this issue. But now we have this public outcry, things are drastically different. I would not disagree that they are in many ways. But legislative micromanagement of this agreement at this time, I do not believe is appropriate. I think that what we need is how we have handled the ICE relationship in the past has been a DOC operational and management issue. They had to have discussions with ICE last summer under the Biden administration because ICE operations were disrupted in Vermont. But that was managed by DOC. I think it's critical that the DOC commissioner retains the discretion he needs to manage operations. And that includes the flexibility to negotiate the ICE detainer agreement. And like I said, I think that if you're going to put drop-dead terms into legislative language, you're going to possibly hurt the very people you're trying to help.
And I understand that that is a way to go to no difference in the MOU. And that may be the governor's intent.
No, that is not what I said. I said that it doesn't mean no difference in the MOU or drop-dead terms that end up killing the MOU. I think it means that we need the discretion to negotiate the terms that work for DOC.
Well, it would
If you
help.
object to
Yeah.
detentions in Vermont, this like little bit of sort of this is, if it's not acceptable for the federal government and we don't have an agreement, you're going to end up harming the very people that you're intending to
Okay,
help.
but Jay, all I would say,
I understand that we are disagreeing.
and what it
I mean, that's,
boils down to for me is that from the governor's office, we've seen only criticism of what might be done, only projection of negative consequences if you do anything. We have not heard a single proactive idea put forward. So
you have heard
wait,
about that idea, and I'm
no,
happy to
no,
go
Jay,
into that.
Jay, let me finish.
Yes, I'm sorry. Just so many testimonies.
I'll remind you,
today.
you're a witness,
Yes.
okay?
Mhm.
So what
I'm sorry,
I'm
Mr. Chair, I apologize.
What I'm saying is, the governor has not so far put forward any concept of how that MOU might be revised. You mentioned operational principles, and it seemed that maybe in there, you're thinking of some ideas how we might change the MOU. People can't be moved out at 3 a.m. perhaps. You mentioned that. You mentioned, can they be detained longer than a week? If the governor would give us some direction, instead of forcing everyone else to go out ahead of him, it would help us. But what I feel is happening is people are terrified of what's going on in certain instances. And the governor is standing there saying, either nothing will be done, or you're being hysterical, or calm down, we'll rise above. There's no direction coming from the fifth floor. I'm sorry.
Well, as you heard in testimony, I'm not sure you were here, immigration is solely a federal function,
Mhm.
right? There is nothing we can do to control federal immigration. We can make Vermont an island, but we actually honestly don't have the money to support Vermont as an island. And we rely on our federal partners in any number of contexts, right? We rely on federal funding to a tremendous degree. We currently comply with federal law. We comply with federal law under the Biden administration. We comply with federal law under the Trump administration. It's as simple as that, right? There's a lot of rhetorical swirl. I understand that people are afraid. I understand that people are demanding responses, but these responses are, when you look beyond what the emotion that you're trying to capture, you're not actually helping the people you say you are trying to help. You're delivering false promises of security, or you're saying we can control this detention agreement so only the people we want are in our facilities. It's a national system of detention, as you noted in your objections, right? So it may be an all or nothing proposition, and you would have to be prepared to live with that. And that would mean that people with hearings in Vermont could not stay in Vermont. And people who are residents here could not be detained here. And that would be a legislative policy decision. And I know that you don't like being put in the position of, well, all these bad things will happen, but you have to understand that all of these bad things could happen.
I fully understand that you yourself acknowledge that there have been many changes in how this administration is acting as opposed to the Biden or the Obama administrations. They are pushing the boundaries in 1,000 different ways every day. And it is incumbent on states and honestly municipalities and everyone to figure out how to respond to that. What I'm saying to you is I find your testimony unhelpful in that it's not proposing anything that will move the needle on what is the largest problem facing us. And honestly, to finish, the governor is not going to be allowed to remain in this crouch, this protective crouch forever. He's going to be forced into some kind of action. And I think it's better to do it in cooperation with the legislature rather than telling us whatever we're trying to do is going to injure the people we're trying to protect. And certainly that's a concern, but we are trying to act as opposed to remain passive victims of a now vindictive federal government that's threatening all of our federal grants, our highway money, our Medicaid money, threatening to crash our economy if we don't comply with whatever the administration says.
No, comply with applicable federal law.
Well, that's in this instance. I'm talking broad brush.
Broad-
Interject
broad
here,
brush.
because Senator Bohofsky has had it for a while. And to avoid lengthy back and forths. So, Senator Bohofsky.
So I do appreciate the acknowledgement that these are really different times and we're not seeing the normal application of the law. And I think we as a state need to, at a certain point, draw the line as to whether or not we are willing to be using state resources to be part of ICE sanctioned human trafficking, because that is what is happening. To avoid due process, to avoid the judicial system, people are being abducted from their communities, moved out of that jurisdiction. And I think we do need to draw a hard line as to whether or not we are going to support that. It was illegal to move Jewish people out of Nazi Germany. At a certain point, what is legal, you don't comply because it's wrong. And so I think that that's the point we're at, is asking ourselves, is this morally wrong, even if it is legal? And so I don't think we are in the same times as we were under the Obama administration and under the Biden administration. That is not what we're seeing. So I appreciate you putting on the table what some of the unintended consequences could be, but I don't think doing nothing is an option. It's a statement, not a question.
Please feel free to respond.
Yeah.
If you want, but otherwise I can Senator
Obviously,
Mattis.
you're very passionately held here.
Senator Mattis, you have your hand up.
Yeah, so I'm at the beginning of the testimony, I heard it on YouTube on the way in. Very confusing topic, situation. I believe this body has passed out S-44. It's doing whatever it's doing over in the House. But S-44 was granting to continue the governor negotiating these contracts, correct? That's something where the body stood
It's a bit different.
and honing those in.
It's different than what
Yes,
this,
that's
than what we're talking about now.
But it's still dealing with immigration contracts, correct?
Potential.
Yeah.
Agreements, yeah.
So now we're talking about the original bill had legislative approval in it, and we took that out, left it with the governor. Now we're trying to put guardrails on what the governor can do, is what we're talking about in this bill.
Yeah, we don't have language, but that seems something suggestive.
Yeah.
Is that the MOU conversation?
Yeah,
Or the,
I would love to be privy to that conversation. I hear it's in people's mailboxes, but as a member of Judiciary, I don't have it. And I'm disappointed in that, because the first time don't want to hear about it is when somebody's sitting in the chair. So I'm pretty disappointed in that. But it sounds like other people have it in their mailboxes.
so
So I'm a little
gonna
confused
interject here
about,
So for example, I don't have, access to your inbox and conversations you have with Ledge Council. So individual senators are allowed to have conversations with the council about potential bills they want to introduce.
of course.
So as we've been talking about the MOU, this is the conversation we're having, where we're now talking about potential policies that we can all discuss here in this committee. And you're part of that conversation. So I'm not sure I understand what your concern is, that guardrails are being created for the governor.
Well, we passed S-44 kept that with the governor. And now we're coming back around, took the legislative approval out of it.
So if we establish policy
Two
related
different
to
situations, but
what happens in state facilities to a certain extent, we can create policy and to say, such and such guidelines are required in in our jails or the probation and parole or in state attorney's offices or whatever it might be, to a certain extent, and as long as we're not overstepping into other branches of government's duties. So we can create guidelines establishing, what happens in correctional facilities, and that's just the conversation that we're trying to have.
I don't know why Jay would think that she would be giving testimony on a DOC issue when I have no idea what the DOC issue is. When we're talking about this proposed legislation, I'm just really confusing. It sounds like Jay was a little
Have you
confused
not-
as well.
Been present in any of the.
I'm talking about giving specific testimony on proposed legislation.
This is the second time we've had this conversation and we directed Ben to work on changing language that had previously been.
Yes. But when there's no language to look at, what is?
Well, it's coming. So as the chair said, they've asked for language. It's in their inbox. They'll look at it and then they'll distribute it to members of the committee. I feel like we could get niggled to death on the little things. I just want to say, I have been looking at this prison in Venezuela that Donald Trump is very proudly and openly, like, making sure that there's television and photo ops. You have the head of Homeland Security flying down in fatigues and posing in front of prisoners behind bars in Venezuela. And we are moving prisoners through the system that we've been talking about to Venezuela. And to me, there's no difference between that and a gulag or that and a dungeon.
Concentration camp?
Yeah, I mean, it's just mind blowing for me. And so that's where this conversation and the passion around it originates, is that we are looking on our televisions and then you have Donald Trump joking, not joking, about the next group of detainees in Venezuela will be homegrown criminals. That is, American citizens who are considered violent or whatever will be shipped to Venezuela. And, I can't put it any other way. I'm not going to be a part of that. I'm not going to let, if it's up to me in any way, even if it's only voting, I'm not going to let Vermont be a part of that system, shipping people to Venezuela, shipping people to places where they can't get due process. So if it is erring on the side of caution or overly passionate, I apologize, but these are just astounding circumstances. And I believe the governor of the state should have a proactive stance where we are doing something rather than saying, let's rise above and do nothing. And that's
So
the
I mean,
thrust.
I understand your testimony. I would just say that that doing something, as you described it, will not do anything about Venezuelan prisons, right? I mean, and what we can do is what we can do, which is treat people well in Vermont when they're detained here, right? That's what we do now. That's what we will continue to do in 4 years. That's what we would do. And that's what we have done in prior administrations. But I understand this is your position, strongly held. We're not going to debate that. I would like to close by saying that we need to be moving in a more constructive direction. The governor has mentioned this. He will be working with other governors on ideas to expand guest worker visas. This could include a state-sponsored guest worker visa program. This obviously requires bipartisan federal legislation. And at some point, we will need or appreciate the support of the federal delegation and the legislature. Right now, this is a proposal that's coming together with other states in a bipartisan way, because I think there's tremendous amount of interest in this. So this is the positive direction that the governor is taking. And I think that we would appreciate legislative support as opposed to support.
I would be all for that. I just believe federal legislation on the immigration issue or guest worker issue is at this point highly. But that's it.
Also just have concern because those visas are being revoked. Like that to me feels like it's putting people in a position where we're seeing an administration that's revoking student visas and trying to revoke green cards. And so offering another way for people to come here and potentially be harmed gives me great pause, but I'd be curious to hear how that unfolds. But I mean, I've told all of my friends and family in other countries, don't come here, it's not safe. So that gives me pause to move forward with saying to more people, come here. We might traffic you to a Venezuelan concentration camp.
Any other questions for Jack?
Yes, I'll oppose to saying, I think America is as safe as we can get. I don't think we're that corner out here that all crime is being hit. And I realize there's a lot of frustration in this community between administrations at a local and federal level. Take that up and down. It came up and down the road several times here. I like the program. I don't know what the solution is besides this. I've talked about visa programs, workers coming in. We have the fruit pickers that come in here, not the fruit pickers, but the guys go and pick apples, whatever else and girls. And I think that our farming communities and other contractors in the state of Vermont need these individuals to come in and work and make Vermont prosper. So to simply kick down an idea that would give them that opportunity is just goes beyond. I don't know what the solution would be after that. If we could at least work with our federal delegation, they should be doing this. These are federal laws. They should be changing these laws so that we do have this opportunity for these folks to have.
Share that.
Thank you.
Thank you.
Thank you, Laura.
Hi, how's everyone?
Oh, great.
Good morning. My name is Jennifer Morrison. I'm the Commissioner of Public Safety. And if I understand correctly, I'm here to talk about the proposed bill S-148. Is that, are we on the same page?
Yes.
Very good. So he wade into a swamp full of alligators, but didn't need to.
We'll keep it narrow on this.
Yes, sir. To frame up my remarks, I want to acknowledge I'm hearing it. I'm feeling the temperature in the room. We are very aware that this is a very difficult time, not just in our state, but in our country. There's a lot of fear. I want to be sensitive to the fact that there is true fear and uncertainty in many of our communities. And against that backdrop, S-148 demands that we respond to what's being proposed, and the Department of Public Safety strongly opposes S-148. I will go through several reasons why, but I will start and finish by saying that we have done proactive work, Senator. In our fair and impartial policing policy, we did that work on Blue Sky Day over years and years. I remember sitting with Will Lembeck in his office back when I was a Burlington police officer talking about this policy. And that goes back a ways. This work has been going on for more than a decade in Vermont. And on a blue sky day, many blue sky days, we did this work proactively so that when it started to storm, we don't have to make it up as we're going along. And this policy has been weighed in on by the legal experts, by the general public, by Migrant Justice, the ACLU, and many, many other stakeholder groups and individuals. So I would submit to you that we already have a balanced approach from a law enforcement side. I'm going to let Jay's corner of the world around contracting Department of Corrections be a different piece of this, but S-148 would replace the fair and impartial policing policy with an inflexible sanctuary state statute that conflicts with federal law. It jeopardizes critical funding, and it would make our communities less safe. So the first question I ask is, what is the problem we are trying to solve? I hear what you're saying, and there's nothing in S-148 that would have prevented the situation in Colchester doing a call-in to come to the immigration office, or the situation at the farm, the Purrier farm. Nothing in S-148 would stop those situations from happening. And there is no problem that I am aware of in the state where local, county, or state officers have been involved in an immigration matter. And if there is one, someone please alert me to it, because it has not happened. And so this is, again, a solution that harms the state, and it is a solution in search of a problem. S-148 is driven by a strong desire to declare Vermont a sanctuary state, but it's not driven by any documented failure in the fair and impartial policing policy or in any current practices. There is no evidence to show that cooperation with Border Patrol or ICE has harmed migrant communities in Vermont. And there is concrete evidence that passage of this bill will harm Vermonters, and I'd like to lay out 5 concrete buckets of impact. Again, these are just 5 that we picked off the many that we could have brought to you, but understanding the time constraints, I want to raise these 5 issues for your awareness. The first one, as many of us have probably brought up, is legal compliance and litigation. S-148 directly conflicts with Federal Code 8 U.S.C. 1373 and 1644, and with Vermont's own law of 20 VSA 2366 subsection F. If S-148 were passed, the Department of Public Safety, along with all agencies and departments of the state, would be unable to certify that we comply with federal law on any federal grant application. And in a moment, I'll explain to you the devastating consequences of not being able to attest to that. Further, loss of certification invites a preemption lawsuit from the Department of Justice that could freeze S-148 for years and drive up legal costs and never get to the end line that this bill proposes. If we do this, DOJ will certainly file a lawsuit, and it will freeze passage or implementation of the bill, and it will probably last longer than the Trump administration, and it will cost a lot of money. And in the meantime, all our federal funds will be frozen. So legal compliance and litigation is bucket number 1. Bucket number 2 is funding risk. A little bit lengthy here, and this is not all inclusive. When I think about Vermont emergency management and the funds that would be at risk there, we depend entirely on planning grants. For instance, our emergency management planning grant is $2.7 million a year. This is what keeps the emergency operations center staffed when there are disasters or emergencies. Approximately 900,000 of that is the personnel, and the remaining funds statewide funds and other emergency management personnel statewide. It pays for our access to web EOC and the Vermont alert platforms, which have been crucial in getting the word out, not only about road closures and such, but of flooding and imminent risk harms to Vermonters who subscribe. Money goes towards supporting the fleet of vehicles used in emergency management, technical upkeep, contracts with our planning commissions, approximately $500,000, and losing the emergency management planning grant would gut the state emergency operations center's ability to coordinate disasters in real time. Likewise, the Homeland Security Grant Program is approximately $600,000 a year. In that money, $600,000 of HSGP goes to pay regional coordinators who deliver local trainings, exercises, incident command structure courses, preparedness conferences, a learning management system, and evaluator contracts. That's all support provided to local communities so that they are prepared for disasters. Without this portion of the HSGP funds, towns would lose their frontline preparedness coaches. Vermont Emergency Management also relies on public assistance and hazard mitigation disaster grants from FEMA to recoup its salaries and facility costs after each declared disasters. Those reimbursements depend on federal compliance certifications that S-145 would jeopardize. Can you imagine what recovery from the floods of the last 2 years would look like without these funds?
I gave a lot of thought to that because those funds are already in jeopardy.
But they're still flowing.
Well, it's clear that the intent is to reduce or stop that.
Let's have.
Yeah, I actually have some, that's interesting you brought that up. I'd love to talk to you about some conversations I've been having through the Homeland Security Advisors Coalition down in Council down in Washington. But at the moment, our emergency management operations are still being funded, and I don't see the planning or response mechanisms shutting off anytime in the near future. There are 51 positions in the Department of Public Safety, 12 disaster grants managers, 12 and a half emergency management program managers, and 14 Homeland Security positions that are 100% grant funded and would be at risk. That's 51 out of 605 full-time positions at the Department of Public Safety. And it is heavily slated towards a planning preparation for what we do best, which is swing into action when things get bad in Vermont. We sub-grant $102 million to 259 sub-grantees serving 151 communities. A funding cliff would ripple statewide, and in fact, it has the potential to bankrupt many municipalities who count on that money. So I'm going to switch away from emergency management and talk for a quick minute about our forensic laboratory and the exposure we would see there for federal awards that are specific to the lab. And as you know, we are the only forensic lab in the state. And the work of my team there is essential for holding offenders accountable for crimes ranging from possession of drugs or DUI straight through to homicide or aggravated sexual assault. The Paul Coverdale Forensic Science Improvement Award is approximately $300,000 each year. It pays for our sole evidence technician position, overtime on seized drug backlogs, analyst training, consumables, calibration contracts, and digital information management systems that underpin every latent print case that we handle. It would take away $600,000 annually from our DNA capacity enhancement and backlog reduction. These funds support a dedicated biology section chemist, overtime for DNA cases, biology staff training, consumables, accreditation, and other support, including probabilistic genotyping software and replacement of DNA instruments as needed. We would also stand to lose $600,000 each year in a National Highway Traffic Safety Administration toxicology project support, which supports another position, toxicology section chemist, toxicology staff training, consumables, calibration contracts, hospital blood draw fees for DUI drug cases, and replacement of data master breath testing units as needed. Why does this matter? These federal dollars underwrite tasks required for our accredited status and for meeting the FBI CODIS participation rules, meaning our abilities to submit evidence to the nationwide database that connects people to crimes that they have perpetrated. Losing them would hobble our drug, DNA, and DUI testing statewide and could jeopardize our accreditation entirely. Never mind that it would hinder our ability to solve and prosecute criminal cases, most of the time being committed against Vermonters. So now I'm going to shift to state police and our intelligence center, the federal dependencies we have there. As you know, the Vermont Intelligence Center conducts many tasks that are essential to keeping our state safe, including assessing threats, pushing information to local and county law enforcement agencies, to schools, to critical infrastructure operators, and many private businesses. We receive approximately $1.62 million per year that pays for analysts in the Vermont Intelligence Center and our Homeland Security Unit staff, as well as as I said, the Vermont Emergency Management Engagement Section personnel. Also, Division of Fire Safety planner, an urban search and rescue program manager. My canon salary is paid by this grant. A radio technology service technician and finance administrators. Cutting the Homeland Security grant program would erase the VIC's analytical capability and leave multiple support positions unfunded. We rely on $100,000 a year in forensic computer hardware in our technology investigation unit. Plus, we have access through that grant to no-cost Secret Service training, which has one of the most robust technical investigation unit supports trainings in the country. If federal support disappears, the state must absorb equipment and National Computer Forensic Institute training costs that now arrive free of charge. Also, under this header is the nonprofit security grant program, which we are the pass-through for houses of worship, hospitals, child care centers, schools, and public event venues that rely on the nonprofit security grant program for cybersecurity upgrades, hardened doors and windows, bollards, alarm and camera systems, and staff training. Loss of NSGP would leave high-risk community sites without modern security protections. Our crime scene search team also relies on this area of funding. For instance, 2 new Faro 3D scanners, each worth together worth approximately $180,000, are funded through the Homeland Security Grant Program. This is just an example of the types of equipment that we rely on, funding we rely on for special equipment that's costly. Without federal dollars, our major crime scene and our crash reconstruction team would revert to tape measures and antiquated technologies to document complex crime scenes and crash scenes. Still in the Vermont State Police wheelhouse, the Vermont Drug Task Force is largely funded by a Byrne JAG Justice Assistance Grant. It funds one full-time sergeant, overtime costs for statewide arrest sweeps. It funds one undercover municipal detective, and it pays for essential operating costs such as buy money, undercover offices and vehicles, fuel and repairs to be able to drive the vehicles, cell phones, and insurance costs. Without this JAG grant, state's only multi-agency narcotics unit would shrink dramatically. We also rely on federal funding through the COPS Anti-Heroin Task Force. That's I'm sorry, COP, I don't want you to be confused and think that with COPS. It's the Office of Community Oriented Policing Service Anti-Heroin Task Force, which pays for a drug intelligence analyst at the VIC. It pays for the Vermont Drug Task Force overtime in certain circumstances, unrelated to sweeps, undercover vehicles, portable radios, in-car video, and transcription gear. We also rely on federal highway safety grants. It supports statewide drug recognition expert training, radar and laser units, preliminary breath test devices, sign packages for the roadway so we can safely execute different roadside activities, and it helps target impaired driving patrols. We also rely on the recreational boating safety grants, which are federally funded, which fund our marine patrol vessels and our scuba team operations, our underwater recovery team. Losing them would reduce our water rescue and our boating safety enforcement capabilities. So the net effect is that the Vermont State Police programs rely on a broad mosaic of federal grants. Losing them would strip investigative capacity, community safety training, and critical equipment from both cities, municipalities, and state assets. I'll take a pause there. I see those questions.
My question is actually for legislative counsel, because we heard testimony earlier, and I just want to make sure I'm understanding it, that it would not be constitutional for the federal government to freeze all of our federal grant funding. That would be considered coercion, not encouragement, correct?
That's my view, but that would be litigated.
So I certainly recognize and appreciate, and trust me, I'm having conversations in every committee, how much Vermont relies on federal funding. And I also recognize that, this is a starting point, and we've already, through testimony, pointed to some places within this language that need to be changed. But my understanding would be that all of our federal funds cannot be frozen.
Well, if they took away our recreational boating funds, I bet we could solve that problem on our own, but we can't make do without the bigger one. Took away FEMA funding. We have communities who would go bankrupt because they've already outlaid the expenses for their fixing their damages. It's an unfathomable future if the majority of these funding streams got shut off.
And my understanding is that there is a not quite drawn out line where there's been two different Supreme Court cases where one said, no, you can't freeze that much funding. That would fundamentally be coercion because it would damage the state so much. And another one that said, that's actually not so damaging that you can't do it. We don't know where the line is exactly. I think you said one was like 1.5% of the overall.
Yeah, one was 0.5% and one was like 5 or 10%.
And so the 5 or 10%, they said, no, you get that. The 0.5%, they said, okay, you can do that. So I don't think we constitutionally could be in a position where the federal government froze so much of our funding that we couldn't function.
Well, I don't want to be in a position of having to pick which ones.
I was just going to say, 10% you pick.
I mean, we're really flirting with disaster. And my point isn't that the money tree won't bloom in Vermont. Maybe it will, and we don't worry about this. My point is that we don't need to go down this path because we did the work on Blue Sky Days to put our state in the position of having a very thoughtful and operational level policy in place. not a knee-jerk, broad sweeping, let's be a sanctuary state policy. So my point is not that the concerns aren't valid. My point is that we've done the work. We did it because we heard the hue and cry a decade ago, and we've done the work in preparation for exactly a circumstance like we're in right now.
And that sort of brings me to the other portion of the conversation that I think is important that would happened earlier, and that is that we may not need to be looking at law enforcement explicitly. It may be the spaces that are not regulated by the fair and impartial policing policy like DCF or AHS. And so there was a broader conversation that I think is just important context for you to have coming in. And just, I appreciate the fair and impartial policing policy. And I sit in a space of statute being stronger than policy. And to your point, people are still really afraid. And we have testimony that they're not going to doctor's appointments, they can't pick up their kids. So there's something has to be done.
But passing this law won't change that.
Right.
And that's the point. That's the point. You're giving people false sense of security, and the damage when you've said you're protecting them by passing a law and they're still getting call-ins at immigration offices or being picked up in a doctor's office. That is, you are breaking trust with the state government in a huge way. So I you know, as a Vermonter, as a mom, I'd say, please don't promise security that you can't deliver on. So getting back to my 5 buckets on number 3 is day-to-day investigations. S-148 would cripple law enforcement's ability to investigate certain crimes or incidents. Blanket silence, demanding blanket silence makes it impossible to untangle immigration facts from drug cases, gun trafficking cases, child exploitation, and human trafficking cases. It is never so clean cut that you roll up on a case and it is exactly what you think it is, and it's only one type of violation going on. It is usually a hot jumble of things that you have to then figure out for what do you have probable cause. But a blanket silence between us and our federal partners would cripple our ability to discern what's going on in any given situation. In fact, a recent joint human trafficking case with the U.S. Attorney's Office depended on immigration intelligence. And I know that you're going to be hearing from ICAP Commander Matt Raymond too. I believe you're going to be hearing from him.
We already did.
Okay, so I won't dwell there at all. Most importantly, S-148 ignores that sometimes there are dangerous people present in Vermont without lawful authority, and removing them protects Vermonters and our communities. It is the case that there are people in the state of Vermont who are harmful to our communities, and they need to be removed. And to think that the state or local authorities could not cooperate with ERO or ICE to remove a convicted murderer, a dangerous gang member, or something else is absolutely absurd and goes against the oath of office that I took when I swore to become a law enforcement officer and that I continue to take as the Commissioner of Public Safety.
Commissioner, I just have to interject that there is an exception to what you're describing on page 3, starting on line 3. Just to clarify, it's not like we're trying to make things dangerous.
Unintended consequences sometimes have a funny way of making things less comfortable, but I appreciate you calling my attention to that, and I will review it as I leave here. The 4th bucket is our northern border response capacity. I want to point out, and I'm sure Senator Norris can provide his own information to you on this, that the Customs and Border Patrol is often the first responders to incidents that happen along our northern border because they care about Vermonters and because they are willing to respond to calls for which they don't ultimately have jurisdiction. I will call to your attention that they frequently respond to EMS calls for service and are the first person there to render aid to people who are in danger inside our borders. They respond to school threats. In fact, they respond more quickly than we can on many occasions. I can recall an incident in North Europe where 3 men were involved in basically a shootout in a driveway of a residence right off of Route 2 over access to hunting at somebody's hunting property, whether or not access was granted to someone and not the other. Border Patrol was the first on scene, took the third party into custody to secure the scene and rendered first aid to the 2 people who were shot. They were there long before troopers or sheriff's deputies were able to get there. So cutting ties and not communicating openly and clearly about the nature of incidents that are happening along our northern border could potentially mean that there's slower response to domestic violence, school threats, EMS calls, violent calls in our community where the first responder is going to be CBP.
Just to clarify, of those incidents that you just described, fall specifically to sharing information about immigration.
They are potentially sometimes all mixed up. If you are responding to a domestic violence incident on a farm, at a home where you don't know who the residency of any of these people, it is often the case that CBP is the first responding unit, and to not be able to share information about the nature of the incident makes it very difficult to ensure that we are properly investigating the incident to hold offenders accountable, but more importantly, to protect victims and future victims. So the point is that response to ongoing incidents can involve people who are here without lawful presence, but you don't know. And to not be able to talk freely and openly with our federal partners when responding to things that on their face may not be immigration related, but ultimately could have a nexus to immigration, is an impossible knot to untangle in real time while you're responding to calls. A blanket.
I get what you're saying, but I think that is pretty clear in your differentiation, but I'm not gonna.
I might just jump in on this one. I can give you examples where people have been tied up for on patrol. Okay, so our first call goes to CBP. CBP shows up, assists our agency. They want to de-escalate the situation along with protect the citizens. The minute they get there, unfortunately, someone may be in violation of an immigration status. And the first thing he said is, oh, well, the sheriff's office called Border because they knew when we hadn't even arrived on scene yet. So, if you just cut off our feet here and our legs, that's we're not going to provide that safety to our communities that we're supposed to be providing.
And you don't want to put a chill. You don't want to further chill an already cool relationship with our partners at the northern border, because when we try to cut off meaningful communication between our federal partners and local, county, and state officers, it will have a spillover effect to these other incidents that I'm also referencing. There has to be clear, open communication between them in order to maximize the ability to keep Vermonters safe. So I point that out that CBP is frequently doing the work of local, county, and state police officers, and it has nothing to do with them going out looking for somebody to detain. But they are our partners in keeping Vermont safe, and to make the communications flows more complicated is not going to benefit Vermonters.
Is there an MOU or agreement or contract for that type of reciprocal work?
No, they just go. They monitor our radio channels, and they frequently respond and can get there because of where the call might be. If it's along the northern border, they get there before we do. At any rate, bucket number 5 is victim and community safety. S-148, as I've just mentioned, creates an enormous barrier between us and our federal partners. And more granularly, it would bar DPS and local and county police officers from helping crime victims apply for T and U visas. If we can't talk to immigration officials, how can we help a crime victim get a visa to stay in the country? I mean, do you want to add a carve out? But these are just examples of when you enact broad sweeping measures, there are unintended consequences that harm crime victims, and this is one of them. So these are 5 buckets that are only a sampling of the harm that S-148 would cause, but more importantly, S-148 would not prevent any of the federal immigration activities of the past few months. It simply wouldn't. There are additional risks the committee should weigh. I think you've already heard that federal retaliation has already been signaled. It's on April 28th. The White House issued an executive order which directed the Department of Justice to list sanctuary jurisdictions and pursue grant funding within 30 days. We would go straight on that list. I also think you should weigh the fact that public sentiment, national polling shows that roughly half of voters believe sanctuary policies make communities less safe. Branding Vermont as a sanctuary state is unlikely to reflect the majority will here at home or abroad, and it will not make us more safe. Lastly, it'll create operational chaos. It would create the need to rewrite policies, to retrain to a new standard, inevitable mistakes that could expose officers and towns to civil liability. Whereas we have the current FIP policy that has been highly vetted and it has been trained to, and police agencies understand it. It provides operational guidance. It is very thorough. And it pushes cooperation limits as far as federal law allows. And it's working. We have no evidence to believe it's not working. So I don't know why we would take this extra step when we did the homework ahead of time to prepare for a day just like today. And I recognize how scary a time this is. We all lament the actions that have happened. I'm going to call out particularly the action at the Courier Farm. But this law will not change any of those, and it will in fact create all of these downstream harms to Vermonters. So I urge you to let the FIP policy do what it's already doing and not do this.
Committee, any questions or comments?
He missed most of the part about the preparation, the proactive,
Get with there tomorrow.
yes, I'll be there tomorrow, but not.
So much censure free.
Okay,
Chance to do it all over.
thank you, sir. All right, let me know if you have questions.
Thank you.